May it please the Court, I'm Wendy LaQuasto here from Fox & LaQuasto representing Mr. James Owen, who is the claimant in this workers' compensation appeal. I'd like to reserve 4 minutes for rebuttal. This appeal raises one issue, which is a contract issue concerning the location of where this contract was made. The state or location of where the contract was made is dispositive as to whether Mr. Owens is entitled to workers' compensation benefits under Florida law. The precise issue in this case is whether the JCC erred as a matter of law in determining that this was a unilateral employment contract that was completed in Utah when claimant went there to start work.
What is a unilateral contract? It seems to me that no contract, if it's a contract, can be unilateral. I mean,
yeah, I don't know. It seems to me that
it's a contract which is accepted by conduct.
And I think that by current terminology, it's an offer to contract.
It just describes the mode of acceptance.
Yes. I agree that it's
so the question is where this was accepted is the dispute here. Is that it?
That's right, okay. Where this was accepted. And I think that we use this term unilateral and bilateral because that's how the case law has brought it up, and it's kind of old case law, and I think that we've updated. But I agree with what Judge Schwartz is indicating, that unilateral contract is really just a mode of acceptance. And the mode of acceptance here was involved in the conversation that occurred between Mr. Baker, the president of CCJ, and claimant, Mr. Owens, when after Mr. Owens was qualified by Fleet to drive, they had a conversation on June 17th while claimant was in Florida, and at that point there was an agreement, a meeting of the minds, an acceptance of the offer to work. And so claimant maintains that the contract was made in Tampa when the employment was accepted, and that going to Utah was simply the beginning of the performance.
The ticket was provided by exactly. One of the putative employers. Correct?
Exactly. And that was all, and so the contract was made in Tampa, and that's our position, is that it was a Florida contract, and therefore the JCC.
Do you know exactly what was said during that conversation? I mean, I believe the record said that the JCC's order said that Mr. Owens testified that Mr. Baker said you're hired. Did the JCC find that that's what happened?
I think the JCC's orders, the orders indicates that there was conflicting testimony. She said, Mr. Owens said, Baker said I was hired, and Baker said, oh no, I didn't say he was hired. You know, I always meant that he had to come to Utah so I could eyeball him and see that he wasn't a drug addict before he was hired.
But of course, that was never communicated, so it doesn't seem like that
right.
And so any part of the contract.
Exactly. And she rejected that testimony by Mr. Baker, that that was a condition to the employment that he had to eyeball him because it was never communicated. I don't believe that she ever actually resolved what was in that conversation because she decided it was a unilateral contract that could only be completed by claimant going to Utah.
I mean, wouldn't we need to know in order to determine where the contract was made exactly what the acceptance was and when it was?
I think that the reason that in all perfect worlds, I think that's all, offer and acceptance, and we need to know when that happens to make a contract. I think that the error in this case is that the JCC reads into the contract the same condition preceding to making the contract that existed in Rahoff. And
right, if you come to Utah, you
right, if you come to Utah, then you'll be hired. She says that's implicit in the contract. So that's what the error is, and that's why some of these questions are not answered, is because she is essentially creating a contract by saying that this condition is implicit in it. So in answer to your question, do we have to know exactly what the acceptance was? I think that that's a question that has to be answered on remand. And I'm not asking for a determination that this is a Florida contract and the claimant is entitled.
Why not?
Well, I am asking that it be a Florida contract, but I'm not asking.
That would be okay with you, wouldn't it?
Right, but I think that there's a lot of issues that need to be resolved yet before there's an employment issue
Well, that's got nothing to do with the point on appeal.
Right. We maintain it is a Florida contract, and that offer and acceptance was done in that conversation.
How could it be made in Utah when the employer provides for his transportation from Florida? Doesn't that assume, isn't it obvious, implicit, or whatever, however you want to put it, that he was employed as the time he got on the plane with their ticket?
I agree. I think that's the case that was in the Chastain.
And if he had not gone, if he'd been sent to, if the ticket had been sent to Tampa and he didn't, for some reason, he found a better job and he didn't go, wasn't he at that time subject to a lawsuit?
And that's what I pointed out in my reply brief. It would be a different story if this ticket was sent to him and, Mr. Owens had decided to go see the national parks in Utah instead of showing up for work. And then Mr. Baker couldn't fulfill his contract with Fleet. I think that coming and going...
What if they hadn't sent him the ticket? Could he sue them for breach of contract?
Well, I think that then we would have had to wrestle out whether you sending me the ticket was actually part of the contract.
Yeah.
Well, wasn't it? I mean, it seems to me that was one of the terms of the contract. You come up here, we do all this screening, we find out if you're qualified to drive the truck. If you get through all of that, we'll send you the ticket. And then if they didn't send him the ticket, wouldn't that be a breach of the agreement?
Well, I think it was in this case that Mr. Baker did agree as part of his conditions to send him a ticket so that he could come to Utah and begin the work there. I think that they could have negotiated so that Mr. Owens would have had to get his own self to Utah, but that's not what was done.
So you think we can presume then or assume what the mode of acceptance was?
I'm sorry, I didn't...
We can assume that the mode of acceptance was over the phone and that the contract was completed, and then Mr. Owens said, and I'll see you in Utah.
Right. I think the mutual promises that I've set out in my briefs are that Mr. Baker agreed to employ Mr. Owens, that he agreed to allow him to drive truck 1882 under the lease that was with Fleet, and that he agreed to provide him with a airline ticket so that he could come up.
And then when Mr. Owens got to Utah, there was nothing further to do in order to complete that contract.
Hey,
there were no further interviews. There was nothing further except in Mr. Baker's private thoughts, I want to eyeball this guy and make sure he doesn't look like a drug user.
And I think that the record bears that out. I think both Mr. Baker and Mr. Owens talk about it's really a perfunctory greeting. Mr. Baker picks him up at the airport. They talk on the way to the truck. He gives him the keys, and they both drive off. I think that's it. And I think that, what Judge Schwartz was saying before about the airline ticket being implicit that a contract was already made, and I think that's also consistent with the coming and going theory that comes in employer-paid transportation.
If the airplane crashed, he would have a comp case, wouldn't he?
I think if the airplane crashed, that Mr. Owens would be able to, and whether he was dead or alive, Mr. Owens or his family would be able to sue for benefits under the fact that it was a Florida contract, because this is employer-furnished transportation. He's on the employer's business at that time. So I see I have a little bit of time left, but unless you have any questions, I'm going to reserve the rest for rebuttal and see what appellees have to say.
Thank you.
Your Honor, I'm Kevin Leisure. I'm here on behalf of Fleet Carrier. I also have with us Mr. Dunbrack, who's representing Pinnacle, as well as Mr. Dowling, who's representing
Both of these
the
gentlemen are your carriers, correct?
They are the attorneys representing two insurance companies who are involved in this.
But they represent your carriers.
That is an issue I don't think has been completely fleshed out, Your Honor.
Okay.
So
But
we're kind of at the very initial
If they have any
stage.
business being here at all, it's because they're alleged to be your carriers.
Apparently, yes, Your Honor.
Okay. They are not related to CGF.
The CCJ, it's my understanding, no, Your Honor. CCJ was unrepresented throughout the entire matter.
Okay.
Your Honor, I wanted to...
If there was nothing more to be done once Mr. Owens got to Utah, why can't we conclude that the contract was already completed by the time he left Florida?
Because before he left Florida, there was never any acceptance by Mr. Owens to the offer that had been made to him by Mr. Baker.
Well, isn't the question of acceptance or non-acceptance judged by an objective theory? We have an objective theory of contracts. In other words, I think maybe you're relying on what was in Mr. Baker's head. He didn't really intend to accept it. But on this evidence, isn't there objective evidence of acceptance when the ticket was sent and when he got on the plane?
No, Your Honor, I don't believe there was. What
does that mean? What does that mean?
What we have here was an offer. I mean, there was a whole qualification process.
And when in your mind was it accepted?
It was not accepted until Mr. Owens actually arrives in Utah.
And what?
What's the significance of that?
Because there's no way he could have performed the job prior to that time, which is what
Yeah, but you could accept the job. I mean, why would you go out there if you didn't accept the job?
You can make a contract before you start doing
Well, I think we're kind of in stages, and that's what the Rahoff case.
Maybe he started the job.
Well, according to Rahoff, what Rahoff tells us, Your Honor, is that he could have, by accepting the ticket, and we'll start with that part of it
Yeah,
here.
but is Rahoff applicable here? I mean, there's no evidence that Mr. Baker said to Owens, if you come to Utah, the job is yours, which is what happened in Rahoff, isn't it?
That is true, Your Honor. But there's also no evidence that prior to that time that Mr. Owens ever told Mr. Baker or anybody at CCJ or Fleet that
But
he
there was
accepted the
nothing
offer.
more for him to do once he got there. I mean, there's business about Mr. Baker wanting to eyeball him. That was really just a private thought that Mr. Baker had because he hadn't communicated that to anybody.
That's true, Your Honor.
And if he got off the plane and stumbled off the plane and was shooting himself up, I assume that he would have breached the contract. He would have said, "You're not grabbing my truck, kid, and I'm terminating you for cause." But that doesn't mean that there was an original contract.
And I'm not disputing that a lot of what Mr. Baker's thoughts were applicable or not applicable, because the judge in this case actually, she threw all of that out.
Well, in fact, yeah, I was going to say, you almost have to say they're not applicable because they were never communicated to anybody.
Right. So it comes back to, well, where is the evidence of the acceptance? And that was really what the issue was. That's what the issue that the judge was struggling with, was where is the acceptance on the part of Mr. Owens in this case? Now, Mr. Owens, at trial, he only argued two different theories for acceptance. One was that once he completed the pre-certification process, that was acceptance then. However, the problem is there was no negotiations for any of the terms of the employment until after the pre-certification had occurred.
Why was the ticket sent to him, purchased by your client and sent to him?
That was part of the offer. That was part of the offer of employment. I'm sorry, Your Honor.
Part of the offer?
Yes, Your Honor. There was an offer made at Mr. Baker tells Mr. Owens.
And how was that offer accepted? Isn't the offer accepted by using the ticket?
Your Honor, again, I'm going to rely on Rahoff on that what?
Rahoff, there was nothing, there was a condition to that contract. If you come to Georgia, you may have a job. You have a job.
Well, okay, well, let me argue it alternatively then. What if he takes the plane ticket and never shows up? What if he walks by Mr. Baker and goes off and takes a vacation on that ticket? Would that be that?
I got a truck here with nobody to drive.
Is the court saying then that would be acceptance then? That because he got on the plane and once he arrived in Salt Lake City, that he decided he was going to go see a basketball game?
No, he's breached it.
He was employed.
No, the contract has taken place, and he has broken it.
Which, of course, are two separate questions, two separate issues, whether it's been accepted and whether it's been breached.
Well, I agree that there is a difference between the acceptance and the breach. I think the problem is what constitutes acceptance. And I don't think that just by offering an airplane ticket, that means that's evidence that there was an agreement.
That we agree on certain terms, therefore, I'm going to accept this job. That seems to be the acceptance.
Why is he going to Utah?
Well, we know ultimately now, we know because of 20/20 hindsight why he went to Utah. He went to Utah to accept the job. But we wouldn't have known that until he actually arrives in Utah.
But I guess
that's the point for us to decide.
He didn't go to Utah for further negotiations. It seems that all the negotiations had already been completed. There were no further negotiations in Utah.
On the basis of these facts, that's correct, Your Honor. There were no further negotiations.
So on the record, you don't have any evidence that there were any further negotiations in Utah.
Correct.
Meaning all the negotiations had been completed in Tampa.
Correct.
You know, there are circumstances in which prospective employers will offer prospective employees a plane ticket to come for an interview. And maybe Mr. Baker had that more in mind, but that wasn't, if you look at this objectively, what a person in the claimant's position would have thought, is it?
I think that's...
I think that's what you're thinking, is that this deal wasn't really closed. He had to go there and all of that, but there's nothing about it. If I were a lawyer trying to get a job in D.C. and some big firm said, well, come up here and interview with us, we'll buy you the ticket, that wouldn't be an offer of employment. But that's a very, very different situation from what we have here, isn't it? I mean, what you have here is not really an offer to come to discuss, to interview, to negotiate. It was come up here and drive the truck.
True, and again, I understand that this Court has made the distinction on Rahoff, but that was exactly what he had to do in Rahoff, though, was he had to arrive at the site in order to be employed.
Because that was a negotiation. Here it seems that the negotiation was, you drive my truck for 25% of the gross, and I'll pay you that, and you drive my truck. That's the mutual promises that were made.
But, you know, I don't believe that I mean, if we get away from the fact that this is a Florida-Utah, I mean, if you make it a more local area where you have a phone conversation between an employer and a prospective employee, and the employer says, you know, geez, come work for McDonald's, we're going to pay you minimum wage, we're going to give you this, we're going to give you that.
Yeah.
Now, is there a contract at that point in time, or does the claimant actually have to arrive at McDonald's for there now to be an employment contract?
Seems like there's a situation you described. Seems like there's a contract, but that the employee doesn't actually begin working until he shows up at McDonald's. But he's begun working pursuant to the contract that was already negotiated.
Your Honor, the way I believe that the case law sets up on this, Your Honor, is that was nothing more than an offer to employ. The airplane ticket, or you know, the airplane ticket may have made it unrevocable, which is what Rahoff talks about. It may have made the offer unrevocable, but it's not acceptance. What is the and we go back. What is the form of acceptance other than the fact that he accepted the plane ticket? Apparently, is what the court is looking at as being the acceptance here. But that is not what.
What remained to be negotiated? Why was this contract not fulfilled?
There was nothing more for him to do once he got to Utah except begin to drive that truck.
Correct, but there was nothing for him to do until he got to Utah.
But
and that's part of the problem here. The equipment is in Utah.
What you're saying is there is no such thing as an executory contract. That if you make an agreement today to start work on Wednesday, it's not a contract until Wednesday. That's silly.
Well, Your Honor, I think that part of this all goes into the standard of review argument here, which is that whether or not that there was any legal error. I understand that the court is looking at the facts, but the fact of the matter is on this is that the judge below had made a finding of fact. She found that there was no acceptance. And part of the problem in this case was the fact that we had a very lively trial with Mr. Owens, and there was some severe credibility problems in which the judge ultimately. But wasn't this finding really more a finding about what do these facts mean? In other words, I don't think that there was a rejection of the claimant's testimony or any material evidence. It's more a question of what. It goes back to my point about the objective theory of contracts. Is it really a finding of fact, or is it a conclusion that is drawn from these facts, which everybody knows occurred? It seems to me the only findings of fact were against your client, or not really against, but rejecting that part about what Mr. Baker thought. Well, actually, no, Your Honor. What they argued below was the second part of what they argued below for acceptance, because they never argued the ticket below. That was not their argument as to what constituted a form of acceptance. What they argued as a constitutive form of acceptance was a phone conversation between Mr. Baker and Mr. Owens.
And the ticket was part of the performance of the contract, which had already been consummated.
But that's not what they argued. What they argued was that Mr. Baker told Mr. Owens, you are hired. That part of the testimony was specifically rejected by the judge. The whole concept here that the ticket was the form of acceptance wasn't. Would that matter, though, if the facts that everybody concedes objectively establish acceptance? Well, first, yes, I do believe it would, because it was, first of all, it's not what was
I
argued
mean,
below.
whether
The
there was
judge didn't have the
acceptance or not
opportunity
is a
to
legal
even-
conclusion drawn from the facts. And it seems to me that if the facts support a finding that there was acceptance, it wouldn't matter what theory the JCC used or.
Well, I think it would be important if the theory that was being argued down below is that the ticket was the form of acceptance, then it would be important then for her to look closer at as to how the ticket came about.
You're beating a deceased horse. That is not the theory. The theory is that the contract had already been consummated, and part of it was that your client was going to produce the airplane ticket. There was nothing else to be negotiated. There was nothing. The terms and conditions of the employment were already decided.
But there was no acceptance. That's the critical part we're missing here.
Counsel, that is a contradiction in terms. When the terms and conditions of a contract have been decided by both sides, there is an acceptance as a matter of law. You can't say there is an acceptance, but there is no acceptance.
I mean, that's the whole point, that the contract had been, it seems that the contract had been formed already.
I disagree. I think you can negotiate the terms of an agreement and not have acceptance. It happens frequently. Many people negotiate terms of agreement that we ultimately decide.
They don't agree.
I could go, let's go back to the example of the D.C. law firm. I could have the offer from the D.C. law firm. We could hammer out all of the salary, the benefits. We could have the give and take.
Yeah, but
and when it's all said and done, we could have an agreement on the terms. And at the end of the day, I could still sit there and say, okay, let me think about it. That would not be a contract.
But that wasn't the case here. I mean, I think if we had a similar case to the example, for example, if Mr. Baker had said that the decision to hire you is subject to a personal interview in Utah, we would have a completely different case.
Because then that would be the last act necessary.
But I don't understand where would the acceptance be after they negotiated the terms of the contract.
If Mr. Baker and Mr. Owens got along and they decided they wanted to work together, the acceptance would be in Utah. But the point is that isn't the case here, is it?
No, the case here is that the case here is that I think, first of all, the term negotiations in this was probably used rather loosely. I think basically Mr. Baker spelled out here are the terms of employment.
Yeah.
And essentially, the e-ticket was provided, but there was never any acceptance.
So you're thinking then that what happened in Utah is Mr. Owen gets off the plane and then says, okay, I accept.
No, I think his action, and that's the missing part here, because there is no verbal exchange.
But if he hadn't accepted, why would Mr. Baker even buy the ticket?
Mr. Baker, I mean, again, that's part of the offer. You're proposing the offer here. Here's the offer. Here's the ticket. If you want to come work for us, then come pick up the ticket. I mean, the fact that he merely purchased the ticket, the fallacy of that argument is what if Mr. Owens never picks up the ticket? Could he sue Mr. Owens then for breach?
He did pick up the ticket.
He
But
did pick up
what if he didn't?
And if he
that
didn't,
was the form of
if he didn't
acceptance.
pick up the ticket, you could have sued him. That's the whole point.
I'm obviously, you're in a better position than I am to determine that.
No, we're not in a better position, but we sure are in a superior position.
That is correct.
We are not right because we're last. We're last because we're right, or vice versa.
Yeah, I think vice versa.
I think vice versa.
But my whole point here, being Your Honor, is that I think he had to go and I think the mere purchase of the ticket and putting the ticket out there as part of the offer does not constitute acceptance. There has to be an action on the part of Mr. Owens. That's what constitutes the acceptance. And it's our position is that he had to be in Utah in order to that was because without any verbal, okay, I'm going to take the job, what other action could there have been to prove that he was actually was accepting the job? So,
okay. Thank you, counsel.
Thank you, Your Honor.
I'm just going to briefly say that I just want to make it clear for the record that claimant did argue below that the telephone conversation was the time when the acceptance was made, and that's at 1784 in the record during closing argument. And that's our position here, is that the telephone conversation is when the offer and acceptance were made, the contract was formed, the plane ticket was part of that. So claimant respectfully requests that this course reverse and remand with directions to find that this is a Florida contract and to consider the other issues that remain pending. Thank you so much.
Thank you, counsel, and thank you both, counsel. The court will be in recess until tomorrow.